start. Learned Counsel for the applicant further submits that as per version of the FIR dated 25/4/2021, the applicant was distributing saris to the voters through co-accused, namely Suman Lata, wife of Chote Lal, whereas there was no such mention of bribery given by the applicant or by his agent or by any other person with the consent of the applicant, which in itself is the most essential ingredient to make out an offence under section 123 of the Act 1951. Learned Counsel for the applicant further submits that section 125 of the Act 1951 is also levelled against the applicant, which talks about promoting enmity between classes in connection with election. But by bare reading of the contents of the FIR, the offence of section 125 of the Act does not make out against the applicant. Learned Counsel for the applicant further submits that the statement of the informant and only one witness, namely Gokaran Singh, head constable, was also recorded under section 161 of CRPC, in which they repeated the version of the FIR. Learned Counsel for the applicant further submits that the allegations made by the informant in the FIR are frivolous, concocted, and are based on absolutely false statements with a malicious intention to harass the applicant, who is a reputed member of the society and has no past criminal record and are not associated with any such activities by far. Learned Counsel for the applicant further submits that it is pertinent to mention here that on 3/2/2021, the Secretary Home Government of India, New Delhi, has issued a letter number 43/2020 to the Chief Secretaries of all the states, in which certain directions were issued regarding withdrawal review of criminal cases resulting from alleged violation of standard COVID-19 protocols on merits. Learned Counsel for the applicant further submits that Honorable High Court sitting at Allahabad passed several orders in CRLP number 7787 of 2021, Vinay Kumar and others versus State of UP and others, for the compliance of the letter dated 3/2/2021 issued by the Secretary Home Government of India. Learned Counsel for the applicant further submits that it can be asserted here that the cognizance taken by the Learned Counsel is based upon concocted facts and no offence under section 188, 171, 269 and 270 of IPC and section 123 and 125 of the Act 1951 is made out against the applicant, and the summoning order dated 5/1/2022 passed by Chief Judicial Magistrate Unnao is based upon the FIR and statements of the informant and witnesses without taking into consideration the material evidences available on record and without any application of its judicial mind upon the circumstances of this case is liable to be quashed. Learned AGA submits that the FIR was lodged based on credible information received by the informant about illegal activities conducted by the applicant and co-accused during the Panchayat elections, and allegations of offering illegal gratification to voters and violating COVID-19 guidelines are supported by witness statements and material evidence collected during the investigation. Learned AGA further submits that the charges under sections 188, 171, 269 and 270 of IPC and sections 123 and 125 of the Act 1951 are applicable based on the actions and intentions of the accused as stated in the FIR and supported by evidence. Section 125 of the Act concerning promoting enmity is relevant given the nature of activities and their impact on social harmony during the election period. The summoning order was issued by the Chief Judicial Magistrate Unnao following due procedure and based on the investigation's findings. The FIR includes specifics about the distribution of saris to voters indicating bribery practices as defined under Section 123 of the Representation of People's Act 1951. After considering the argument advanced by learned counsel for the applicant and learned AGA for the state, this court finds that the allegations brought against the applicant under Section 188, 171, 269 and 270 of the IPC as well as Sections 123 and 125 of the Representation of People's Act 1951 appear to be baseless and malicious. The FIR lodged by the informant Ram Avatar is riddled with inconsistencies and lacks the essential ingredients necessary to constitute the offences alleged. It is well established that under Section 195 within bracket 1 within bracket A CRPC, no court shall take cognizance of an offence under Sections 172 to 188 IPC except on the complaint in writing by the public servant concerned or some other public servant to whom he is administratively subordinate. The absence of such a complaint in this case renders the proceedings procedurally flawed. Detailed discussions of relevant sections with reference to this case are as under. Any gift, offer or promise by a candidate or his agent or by any other person with the consent of a candidate or his election agent of any gratification to any person whomsoever with the object directly or indirectly of inducing a person to stand or not to stand as or to withdraw or not to withdraw from being a candidate at an election, or an elector to vote or refrain from voting at an election, or as a reward to a person for having so stood or not stood, or for having withdrawn or not having withdrawn his candidature, or an elector for having voted or refrained from voting. The receipt of or agreement to receive any gratification, whether as a motive or a reward, by a person for standing or not standing as or for withdrawing or not withdrawing from being a candidate, or by any person whomsoever for himself or any other person for voting or refraining from voting, or inducing or attempting to induce any elector to vote or withdraw or not to withdraw his candidature. For the purposes of this clause, the term gratification is not restricted to pecuniary gratifications or gratifications estimable in money, and it includes all forms of entertainment and all forms of employment for reward, but it does not include the payment of any expenses bona fide incurred at or for the purpose of any election and duly entered in the account of election expenses referred to in section 78. In the instant case, the applicant argues that the allegations do not meet the essential ingredients of bribery as defined under section 123 of the Act. The FIR alleges that the applicant was involved in distributing saris to voters, but it does not specify any direct act of bribery by the applicant or his agent with his consent. The lack of detailed allegations fails to substantiate a prima facie case under Section 123. Section 125 promoting enmity between classes in connection with election. Over.